for coming to this event. It's fantastic that we're eventually this year able to hold an in-person AACL event. And so we've tried to get the best of both worlds by having socially distanced audience here, as well as recording the event. And so my job is really just to introduce Justice Chris Bleeby, who will in turn introduce Fiona McDonald. We had to interpose a judge between the two McDonalds. Justice Bleeby, as everyone probably knows, has recently been appointed to the South Australian Supreme Court and Court of Appeal when it commences. Before that was the Solicitor General for South Australia. We're very grateful, as always, to have Justice Bleeby here to help us out with our AACL events and introduce Fiona McDonald. So I will just hand over to Justice Bleeby now.
Thanks, Steve. Well, it is a great pleasure for me to introduce Fiona McDonald, who, as you know, was, most of you will know, was my counsel assisting for some time while I was Solicitor General. Fiona is currently a solicitor in the public law section of the Crown Solicitor's Office here in Adelaide. She finished up her role as counsel assisting the Solicitor General in July of this year. Last year she completed her Master of Laws. That was conferred with a specialism in public law at the London School of Economics and Political Science, and her studies there focused on constitutional theory, criminal justice and human rights law. And she graduated with the highest overall grade in the LLM. What that means is she came top. Having read her paper more than once, there's the thesis component of that course. It does not surprise me to have discovered that. Now, save for her year of study in London, Fiona's worked for, well, it says here, for the Solicitor General for the State of South Australia since January 2015. She has in fact worked for two of them and also for those who held the fort when there was none. Prior to that, she worked in the South Australian Officer of the Director of Public Prosecutions. She's appeared as junior counsel in 9 substantive full court hearings in the High Court, both as counsel for the Attorney General of South Australia in constitutional matters and as counsel for the Director of Public Prosecutions in criminal appeals before that court. And she's appeared unled in the South Australian Court of Criminal Appeal and in single judge appeals in the Supreme Court of South Australia, and her particular interests are in constitutional law, criminal justice and public law generally. So look, really without further ado, the legend, please welcome Fiona.
Can I just check that everyone can hear me okay? Thank you. So thanks very much everyone for spending your Friday lunchtime with me. That's very, very kind. Hopefully I can hold your interest for the next little while. I'm going to jump straight into it because we don't have that much time and I have lots of things I want to say. The issue that I'm interested in is really this. There are a bunch of people in this room right now who will feel that it is morally repugnant to control, let alone detain, a person after they have finished serving their sentence because they are considered a risk of future criminal offending that they haven't yet committed, let alone had proved beyond reasonable doubt against them. There are also other people in this room who, if you told them that a convicted pedophile who has spent the bulk of the last 15 years serving sentences for serious sexual offences against children and who is currently assessed by medical practitioners as being a high risk of reoffending, is going to be released into the community with the same liberties that you and I have. No control, no detention, possibly living down the road from your kids or your friends' kids or whatever. And there's a bunch of people in this room who would feel that that is an unacceptable or an intolerable situation. And for some of us, and I'm not ashamed to say I'm in this camp, I feel both of those things and they're inconsistent with one another. So what I'm interested in understanding is how we can feel a moral commitment to the former, but also unable to tolerate the latter. And the thing that flows from that as well is that where I land is that this is a really difficult problem. It's morally complex, it's emotive, there are high stakes. This seems really hard. But the other thing that we see is this doesn't seem really hard when it comes to policy making, passing laws in Parliament, public debate in the media. It seems like a very one-sided debate. There are certainly academic commentators out there who are criticising these sorts of regimes, but by and large I think it's fair to say that that's not getting a lot of traction when it comes to passing these laws and playing out in the media ideas around this problem. And I'm not really here to defend or support these sorts of regimes. I'm interested in why does this feel so hard? Why does it look so easy? And what's going on here? How do we understand this phenomenon? And what I should say as well is that this idea of precautionary detention of dangerous offenders, which is what I'm going to be focusing on today, and this idea of precaution generally to criminal justice problems and criminal justice harms is actually, it's not unique to South Australia. It's a trend that we are seeing in other states in Australia. We're seeing it in the UK, the US, New Zealand, Canada. There is a real proliferation of a precautionary approach to criminal harms. Now, I'm conscious I've just used the term precaution to describe this trend, and I'm going to spend a little bit of time today talking about what I mean by precaution, because that has a particular meaning, or I mean it to have a particular meaning, and I think it's a really important integer of what is going on with this trend. So the way that I've tried to tackle this problem is to have a look at the logic that's actually underpinning some of these regimes providing for post-sentence detention of dangerous offenders. This is not to suggest that it's only detention regimes, it's not to suggest that it's only convicted offenders that these regimes apply to. We often see with terror suspects as a good example of people not necessarily convicted of anything who are subject to these sort of coercive state preventative regimes. But for several reasons which I outline in the paper, it's post-sentence detention of dangerous offenders that seems to me to sit sort of quite neatly at the intersection of the state in its criminal justice mode and the state as risk regulator. So that's kind of why I've focused on that. And it seems to me that that logic that's underpinning these regimes is increasingly precautionary in nature. So my talk today has 4 parts to it. First, I'm going to explain what I mean by precautionary logic and try to explain how that logic works and how it looks to guide decision making. Second, I'm going to use the example of South Australia's regime for the indefinite detention of persons deemed unwilling or unable to control their sexual instincts to try to show you precautionary detention at work in South Australia. Third, I want to offer a possible explanation for this current trend towards precaution as an approach to criminality. And I'm going to suggest that it is a shift in where we place the moral responsibility for criminal harms that's driving this. I'm going to argue that it's because the state is now held responsible for a failure to prevent that puts the conditions in place that trigger precautionary logic and make that feel like an appropriate way of reasoning about these decisions. And the fourth thing I'm going to do is, if I get time, is to explore some of the implications that might flow for the individual offender and their responsibility for crime under this kind of thinking. So, precautionary logic. Precaution obviously has a lay meaning. It's roughly encapsulated by the idea of sort of better safe than sorry. And it refers generally to the idea of taking advanced measures to prevent something bad from happening. Precautionary logic refers to a specific manner of reasoning And you might have heard of the precautionary principle. That's a manifestation of precautionary logic, originally derived from German environmental law in the 1970s, but it's become really popular in environmental law and public health law around the globe now. And it's actually the precautionary principle, and therefore a form of precautionary logic, that we're seeing in a lot of the management of the COVID-19 pandemic at the moment. And as I sort of step through how the logic works, you'll be able to see some of that in the lived experience that we're currently having with the management of the pandemic. The central idea of the precautionary principle is that regulators should take steps to protect against potential harms, even if causal chains are unclear, and even if we do not know that those harms will come to fruition. That's the central idea of it. So what is it? Precautionary logic is a mode of decision making, if you like. Logic can be characterised as precautionary where it has these three essential components situated in a particular conceptual relationship with one another. So in their broadest form, where one, there's uncertainty concerning the realisation of a future circumstance, and two, that future circumstance is rated as undesirable, then three, a precautionary response is activated. So the first two components are the conditions that activate the application of precaution, whilst the third gives you the particular precautionary posture that's going to be adopted. So there are degrees of precaution among deployments of precautionary logic. Some will be more precautionary or stronger forms than others. And at the boundaries, the distinction between a weak form of precautionary logic and reasoning that isn't properly characterisable as precautionary isn't going to be sharp, and is often the subject of contest. The other thing to note is that these three dimensions are dynamically interrelated. So stipulating absolute or objective thresholds for each dimension doesn't of itself capture the range of ways that these three components can configure themselves to produce precautionary logic. So for example, where greater uncertainty under condition number one is tolerated within the decision-making process, then a weaker precautionary response or a lower level of undesirability can be tolerated without sort of compromising the logic's precautionary nature. Similarly, if the undesirability of the future circumstance is immense, then the uncertainty may not need to be as radical to still produce a precautionary response. So they are sort of dynamically moving in relation to one another. So first condition, uncertainty. Uncertainty as to whether the undesirable circumstance will eventuate is a condition of precautionary logic. And we can draw a distinction here between the uncertainty of a future circumstance that can nevertheless have its likelihood calculated in terms of strict probability, and uncertainty that just isn't meaningfully amenable to that sort of mathematical precision. And whilst that distinction isn't sort of sharply binary, it's the latter kind, this sort of radical uncertainty that precaution's interested in. So the problem of decision making in circumstances of radical uncertainty is absolutely central to the why and the how of precautionary logic. In the absence of scientific certainty or sort of probabilistic precision, decision makers must confront the reality of wide margins of error, and their decisions can't be outsourced to the science. And the disagreement we've actually seen over Victoria's approach to lifting its lockdown restrictions is quite a good example. The uncertainty around the risk and what approach to managing it is justified can't just be abdicated by the decision maker and answered by the science. There's so much uncertainty in the nature and extent of a possible third wave. The decision makers are forced to make that call for themselves. And what this means is that the decision maker has to choose a posture to possible error in circumstances where the possibility of error is high and their responsibility for error is going to be traceable securely to their choice. So that's undesirability. The second condition is the undesirable circumstance. And Precautionary logic is concerned with a circumstance that is gravely undesirable. That obviously admits of degrees as well, but the degree of undesirability really drives the precaution in precautionary logic. The more catastrophic the outcome, the more likely precautionary logic will be deployed, and the more precautionary that logic will be. So the centrality of the catastrophic outcome to the logic is also what highlights, it highlights that precautionary logic is inherently relational. So you can only be precautionary with respect to something, a particular postulated outcome. It's not a logic that is risk averse per se, it is averse to particular risks. So a precautionary approach to the spread of COVID-19 is risk averse to the spread of COVID-19, but not necessarily risk averse to the social or economic impact of a lockdown, for example. So we get to the third component. The precautionary response is the intervention in the present day that's designed to stave off the future catastrophe. So this includes the nature of the intervention and the occasion for its deployment. And each of those might represent a more or less precautionary stance as well. So for example, if the nature of the intervention is prohibition of the risk-creating activity rather than mere regulation, it will be more precautionary. Similarly, if the occasion for the precautionary intervention is mandated rather than discretionary, you have a stronger precautionary response. The other thing that this dimension highlights is that precaution is always an expression of agency. It's an approach that is consciously adopted, and that will rear its head again a little bit later. So how does the logic work? The graver the potential outcome, the more intolerable it is that its realisation is uncertain. Once a possibility is perceived as catastrophic, nuanced questions of balancing begin to recede, and you start to be replaced with a zero risk orientation. Effective certainty is demanded. That is, the catastrophic event must not happen, despite the structural presence of uncertainty. So the precautionary response tackles that conundrum by manipulating time and knowledge and injecting chosen known costs in the present in place of uncertain possible costs in the future. And in this, it echoes the strategy of insurance as a response to risk, but the difference and what distorts its practical operation is the catastrophic degree of harm being risked and the radical uncertainty of its realisation. And the distortion is one of vast asymmetry. So where an insurance response to risk uses knowledge of harm and risk to calculate a sort of proportionate present day price tag, precautionary logic concedes that knowledge and value have been defeated by uncertainty and catastrophe, and no meaningful price tag can be calculated. So instead, the posture adopted by precautionary logic actively confronts the limits of knowledge by conducting itself on the basis that the uncertainty of the risk ought not stand in the way of prudence. The effect is a really striking new relationship between human knowledge and human decision making. We start to make decisions based not on what we know, but on what we do not know. So, but for all its efforts to transform the uncertain catastrophe into a certainty that it won't happen, precautionary logic, of course, is just a manner of reasoning. It's not providing more information, it's not curing knowledge gaps, it's certainly not time travelling. And that trite observation matters because what it means is that at the very moment of decision, those time and knowledge problems of the uncertain future still fundamentally subsist. So the question is, where have they gone? The answer lies in precaution's relational character. That is, it's precautionary with respect to something. Precautionary logic promotes certainty that its intolerable outcome will not come to fruition by interposing precautionary measures designed radically to reduce the possibility of the catastrophe. But that mechanism only alters the likelihood of the catastrophic outcome. It doesn't alter the uncertainty itself. We still have the same degree of uncertainty in that moment of decision. What they do is they recast the object of that uncertainty. So we no longer have the uncertainty of the catastrophic outcome. We have the uncertainty that the precautionary interventions that have been deployed were unnecessary. And it's that uncertainty that replaces the uncertainty of the catastrophic outcome. So because precaution is one-eyed, the logic concerns itself only with reducing the risk of the intolerable outcome. And it achieves that mandate if it recasts the object of uncertainty and replaces the uncertain risk of catastrophe into the uncertain risk that the precautions taken were unnecessary. And that one-sided risk aversion attracts an asymmetrical attitude to margins of error. If the uncertainty increases the risk of error and demands that the decision maker adopt a posture to it, then the intolerability of the potential outcome makes that choice really easy. False positives, so incorrectly deeming precautions to be necessary, are part and parcel of being cautious. Whilst false negatives, incorrectly deeming that precautions were unnecessary, means the unacceptable realisation of catastrophe. And under this asymmetrical attitude to margins of error, finding an intervention to be excessive or disproportionate becomes increasingly implausible. So in shifting the object of uncertainty, the burden of that uncertainty is also shifted. So for example, when the uncertainty of a COVID outbreak is replaced by the uncertainty of an unnecessary lockdown, the burden of that uncertainty and its unavoidably wide margins of error shifts from those most adversely affected by the COVID-19 outbreak to those most adversely affected by the lockdown. And the other thing that's interesting is that false positives, the error now most likely, are also rendered undiscoverable by the intervention itself. So if the feared catastrophe never eventuates, we never get the third wave, that outcome is equally consistent with an effective intervention as with an unnecessary precaution. Precaution, therefore, not only takes an attitude to error that is asymmetrical, but it also sort of wraps itself in blissful ignorance because, in respect of the realisation of the very error that its intervention risks. Okay, one final point on precautionary logic, and then I'll get to criminal justice. For all its techniques, precautionary logic is little more than a manner of reasoning deployed to manage a perceived problem of an uncertain future. So whilst defeatism about a lack of knowledge is key to how the logic works, shortcomings in knowledge are only problematic if we feel a need to know. That need to know comes from the intolerability of the outcome. The more unacceptable the potential event, the greater the drive to manipulate certainty out of uncertainty and to risk false positives in place of false negatives. But what you mustn't think is that the logic itself does away with the risk of unnecessary precautions. Precautionary logic is adopted where there is a prior attribution of values that leads precaution to emerge as appropriate for the decision at hand. Precaution, therefore, reflects the moral and political choices of its agent. It does not generate them. All right, the next thing I want to do is show you that precautionary logic has in fact migrated into the law and policy of crime prevention. In the paper, I step through in some detail the scheme under the South Australian Sentencing Act 2017 for the indefinite detention of convicted offenders said to be incapable or unwilling to control their sexual instincts. I don't have time to go into the detail of that scheme and all the ways that precautionary logic is structured into it, but I did just want to pick out a couple of aspects that are strikingly illustrative. So the first is to identify that the test for being liable to detention under the regime is not as risk averse as the test for being released from detention once detained. So an order for detention will only be made where the person is incapable or unwilling, and detention is the intervention apt to ensure adequate protection of the community. But to be released from detention, the person must positively establish that they are both willing and able to control their sexual instincts, or else no longer pose an appreciable risk due to age or infirmity. The effect is that the person who is found unwilling, but who is unnecessary to continue to detain in order to protect the community, cannot be released. Once they're in, that person, even if it remains unnecessary to detain them, cannot be released unless they meet those two other criteria. So the second is that in determining an application for release, the court is legislatively required not to have regard to the length of time that the person has spent in custody or may spend in custody if the order is not made. These features, among others, represent a scheme that pursues certainty rather than a true balancing of the competing interests at hand. Its very structure implies that unnecessary detention is contemplated, acceptable, and preferable to a realisation of the reoffending risk. So, precautionary detention in this context, it inverts our traditional criminal justice commitment that doubt ought to favour an individual's liberty over the state's coercion. Under precautionary logic, it is better that 10 persons be unnecessarily detained than one be permitted to reoffend. The uncertain future of possible reoffending against a hypothesised victim is prioritised, whilst the present known cost incurred in its place is the deprivation of the individual's liberty. That cost is not reducible to economic terms in the way that it might be in an environmental law context, where the industry creating the environmental risk has to bear the financial cost of the uncertainty of the risk that they create. And its distribution lacks the universality of the kinds of measures we've actually seen generally used for the management of the pandemic, where everyone, these rules apply to everyone. We all bear the uncertainty and we all bear the cost of the lockdown in order that we all benefit from reducing the risk of the spread of COVID. So these sorts of characteristics alone suggest that direct transposition of precautionary logic to the criminal justice sphere at least warrants some seriously careful thought. It's not, with its cavalier attitude to unnecessary precautions, where those precautions are the detention or strong state coercive control of a person, it is at least pause for thought to think, is this logic apt for this circumstance? So the strongest precautionary features of the Sentencing Act regime that I've just gone through were actually inserted after some amendments in 2018. And those amendments reversed the onus for release so that the detainee had to establish their release. It altered the test so that it was harder to get out of detention than it is to get in. And it's what brought in that provision that precludes regard to the duration of a person's detention. So those three features were all brought in at once in 2018. And perhaps one of the most striking things is that they were completely uncontroversial. They had bipartisan support in the media, and in supporting the government's amendments to that act, the Leader of the Opposition said in Hansard, there is no higher priority than keeping our children safe, and Parliament has a responsibility to act. And this brings me to my third section of the talk. It's that responsibility to act that I want to suggest might at least partly explain our trend to precaution. So my argument is that there's been a fundamental reconfiguration of our attribution of blame for criminal harms. In short, the state is now held morally responsible for a failure to prevent individual criminal harms. And my argument is that in that single move, this reconfiguration of blame institutes the conditions for precautionary logic and make it immediately feel necessary, appropriate, and so forth. So, recalling that the move to precautionary logic is driven by intolerance for a threatened circumstance, in the case of criminal harms, where they are perceived as preventable, their occurrence is considered more intolerable. A perception that a crime was preventable can derive from a whole range of circumstances, but if someone has been previously convicted of serious offences and therefore identified as dangerous, that provides a pretty good example. A common feature of these preventative detention regimes is that they apply to convicted offenders. So the relevance of prior offending can sort of be understood as representing a threshold of imputed knowledge, if you like, of the person's dangerousness and therefore the preventability of their future crimes. It's sort of their prior offending has put the state on notice, and to fail to protect the community from that person once you're on notice is a failure of the state. And so once the criminal harm is seen as preventable, the entity that failed to prevent it becomes causally complicit in its realisation. And it's that perspective of causal complicity that paves the way for the attribution of moral responsibility. People feel like the state is partly playing a role in letting these criminal harms manifest once a person's been identified as dangerous. The very notion that the state must decide when a person completes their sentence for their offending, whether or not to release them, already betrays an assumption that is foreign to traditional retributivist criminal justice principles. And that assumption is that the state is responsible for the criminal harms perpetrated by autonomous individuals that they release. And once that assumption is in place, the state must take steps to reduce the incidence of those harms. So a person's dangerousness signifies preventability, and that future offending by that person takes on a heightened sense of intolerability. And because it's the state here, it's the state's failure to prevent, a powerful sort of element of political cost is also inserted into the equation. So reoffending by dangerous offenders now represents political damage to those responsible for the state framework that regulates these matters, and that drives intolerance for its realisation lower still. So that's the that's the intolerance of the outcome. To the second condition, uncertainty. It's the reconfiguration of moral responsibility that I suggest also supplies this condition of uncertainty. Criminal offending is an event, the future occurrence of which is necessarily uncertain. It is always mediated by the agency of the offender. But what I want to suggest is that the problem of the uncertainty of reoffending is less a function of poor predictive capabilities or weaknesses in science than of an imperative for the state to be certain about the future exercise of an individual's autonomy. So it's because the state must know that uncertainty is intractably inserted into the equation, because these are the products of individual agency. So I suggest that the rise of precautionary detention can be seen as a symptom of this reconfiguration of moral responsibility for criminal harms. By blaming the state for failing to prevent reoffending by dangerous offenders, that outcome becomes both intolerable and uncertain. And that intolerance demands certainty, and the inherent certainty, bound as it is to human agency, human autonomy, can only be defeated by denying that autonomy. That's how you get certainty. So, final section of the paper. We're going for time. Is to just have a think about what this might mean for the place of the dangerous offender in this, under this logic. So if I'm right that precautionary detention reflects some attribution to the state of moral responsibility for crime, the question is, where does that leave the moral responsibility of the dangerous offender? Does the one-eyed risk aversion of precautionary logic discount the risk of unnecessary detention because the relevance of the individual's moral agency has been superseded by that of the state? Or is it discounted precisely because the individual's moral blameworthiness for their dangerousness means that we consider that treatment of them to be deserved in some way? In the paper itself, I analyse in some detail whether precautionary detention of dangerous offenders can be persuasively accounted for on consequentialist grounds or on retributivist grounds. I'll just pick out a few bits of those ideas that are developed more fully in the paper. So the consequentialist account of precautionary detention is consistent with my idea that precautionary detention is driven by an attribution of moral responsibility to the state. If the logic is deployed by the state because it falls to be politically punished for a criminal outcome, then that suggests that the state deploys precautionary logic because of its instrumental quality vis-a-vis that outcome, that consequence. In effect, the moral responsibility of the state for potential offending supersedes concerns for the moral responsibility of the potential offender. The primary moral relationship is now between the state and the public, not the state and the offender. The dangerous offender ceases to be a rational moral agent with whom the state is seeking to engage, like in our typical criminal justice concepts. It's state and offender in a dialogue about, deterrence, rehabilitation, so forth. In this paradigm, the offender instead becomes the object of regulation and a bystander to the primary moral relationship between the state and the public at large. And in relegating the offender to bystander in that moral relationship, there does appear to be a diminished recognition of the moral agency of the dangerous person. In the paper, I conclude that this consequentialist account is an incomplete account of the phenomenon. For example, that the logic is indifferent to error on one side of the ledger, so here unnecessary detention, means that it's indifferent to certain disutility altogether, and that is antithetical to consequentialism, just to ignore a whole bunch of consequences and disutility. A purely consequentialist account of precautionary detention also appears at odds with the fact that its popularity at the moment has coincided with an ever-increasingly a penal discourse that is increasingly punitive and retributivist, tough on crime language. And also it's coincided with a broader political discourse about human rights. So the fact that we're big into tough on crime discourse and human rights discourse is a little bit in tension with the idea that this is a pure numbers game, consequentialist, use the individual to get the consequences and the outcomes that we're after. So it's sort of, it feels like it's an incomplete explanation. So the other alternative is that it's a retributivist style of thinking. And that would characterise precautionary detention as a punishment for a wrong of dangerousness, if you like. So given the uncertainty of the reoffending, a posture to potential error must be adopted, and where the choice is between the risk of reoffending and the risk of unnecessary detention, where you have a dangerous offender who is responsible for creating the uncertain risk, and they're the source of it, they're morally responsible for it, they deservedly bear its burden, would be the way that retributivist sort of account of a wrong of dangerousness would go. Now, if my claim that precautionary detention is driven by state blame is correct, then a retributivist account is also, at best, an incomplete understanding of the phenomenon. But there are other difficulties with such an account, which I canvass in the paper. But one is that the rationale for punishing a dangerous individual appears to depend on their relative culpability vis-a-vis the inherently innocent community at large or future putative victim. And so what that means is it also seems to turn on the unavailability of ways to manage that risk that are less punitive. So if we had alternatives that worked better, precautionary logic wouldn't have a problem with you adopting other precautions. The punishment of the dangerous person is not a necessity or really of interest to the logic. So it suggests that the deservedness of any punishment for dangerousness is contingent on things that are not intrinsic to the wrong. And that makes me very suspicious about a retributivist account. Precautionary logic, of course, also has great difficulty in meeting the retributivist demand for proportionate punishment. For a lot of, those reasons around that asymmetry to attitudes to margin of error, so forth, a proportionate response to the wrong becomes difficult to see. So where I land is that precautionary detention can't persuasively be justified by reference to consequentialism or retributivism, but it nevertheless seems to appeal to values in both and blend them in what is ultimately an incoherent hybrid. So precautionary logic is intrinsically focused on consequences. The values placed on the contemplated outcome take their complexion from the antecedent moral and political values of the agent. It's in that moment that a particular risk is selected for attention, weight is ascribed, and a precautionary posture is determined appropriate. In that moment, the state is confronted with its presumed power to prevent and the prospect of political punishment if it doesn't. This provides an impetus for precautionary detention and makes the state's moral responsibility a central concern. The individual's moral responsibility is relegated to second place, with notions of diminished agency heightening the perceived necessity for the state to take responsibility for averting this future criminal event. But just when consequentialism falters in attempting to justify its indifference to the unnecessary detention of a person, in swoops retributivism. Concerns can be allayed by the relative blameworthiness of the individual for revealing themselves to be dangerous, next to the inherently innocent community with which the dangerous offender must compete. Their moral blameworthiness operates permissively. It neither drives nor persuasively justifies precautionary detention, but it lubricates its moral acceptability. The result is a dangerous offender who seems incredibly vulnerable to the political and moral forces that are tugging on the state. They are at once morally responsible enough that their detention feels just, and irresponsible enough that their detention appears necessary. And where the responsibility of the state for preventing criminal harms constitutes an ever-expanding universe, the population of those vulnerable, dangerous offenders is only likely to grow. All right, I'll wrap up. So, where precautionary logic is structured into decision making, an intractable uncertainty and an intolerable outcome can be inferred. The rise of the logic in criminal justice, and particularly in the post-sentence detention of dangerous offenders, can be understood as a direct function of a reconfiguration of responsibility for crime. By blaming the state for a failure to prevent reoffending by dangerous offenders, the ongoing autonomy of those people represents intractable uncertainty, whilst the perceived preventability of the future criminal harms and the consequent political punishment inflicted for their realisation heighten intolerability. In a single move, precautionary logic emerges as intuitively necessary and appropriate. However, this reconfigured emphasis on the state's responsibility for crime also distorts orthodox conceptions of the individual's responsibility. Under precautionary detention, the state's appetite to foreclose the autonomy of the dangerous offender in the name of precaution is accommodated partly by discounting their character as a rational moral agent and partly by invoking it. So all of this suggests that any efforts to curb the practice may need to engage with an underlying political dynamic concerning the state's role in preventing criminal harms. It seems to me that so long as we blame the state for the crimes committed by those that they release, we deter the state from granting freedom and liberty to those people, and precautionary detention will be here to stay. And so that I don't finish on a completely depressing note, I think we can identify a useful confluence of interests here. Blaming the state for criminal offending by autonomous individuals exposes the state to political damage for inherently uncertain outcomes and encourages ever greater limits on our freedom. If I'm right, then the state, the citizen, and the offender all share an interest in revisiting the moral and political assumptions that underpin precautionary detention. Thanks a lot, guys.
I'd just like to make a few comments. It won't surprise you to know I have this paper and its extraordinary insight into a re-foundation of the problem in a particular way that it describes something that at one level or another probably I suspect everybody in this room has thought, what's going on here? This gives us a framework of understanding that I think is very clear from this Fee's last comments, is allows us a platform to think of then about what happens next. And I just wanted to perhaps comment on one aspect of what happens next. And I just need to do that. I want to go back to one sort of central conclusion that Fiona's drawn, and it's about the moment where the state is confronted with its presumed power to prevent and the prospect of political punishment if it does not, and that this provides an impetus for precautionary detention and makes the state's moral responsibility a central concern. So what then do we expect of the state, and what kind of power do we expect the state to wield? And I don't just simply mean power to detain. I'm talking, are we talking executive power, are we talking legislative power, or are we talking judicial power? And this is not only then a question of what is the moral responsibility of the state, but where are the constitutional limits of the state in responding? And it, most people in this room will be aware that the High Court has begun to engage with this question of the kind of power that the state should be bringing in the case of Vella and the Commissioner of Police in New South Wales. Now that, as you know, concerned the Serious Crime Prevention Orders Act 2016 of New South Wales, and this dealt with a facility called Serious Crime Prevention Orders, and Section 5 sub 1 of the Act said an appropriate court may, on the application of an eligible applicant, make an order, a serious crime prevention order, against a specified person if, and you know there are some criteria there, and it involves if you've been either convicted of a serious criminal offence, or the person has been involved in serious crime-related activity for which the person has not been convicted of a serious criminal offence, including by reason of having been acquitted of or not being charged with an offence. And the court is satisfied that there are reasonable grounds to believe that the making of the order would protect the public by preventing, restricting or disrupting involvement by the person in serious crime-related activity. So immediately here we see the state is inserting criteria of certainty into that which, as Fee has so eloquently described, is uncertain. And then Section 6.1 provides that a serious crime prevention order may contain such prohibitions, restrictions, requirements or other provisions as the court considers appropriate for the purpose of protecting the public by preventing, restricting or disrupting involvement by the person in serious crime-related activities. And so here we had a case where there was a directly judicial function placed on the courts in engaging in the very exercise that Fee's been describing. And I really just want to just draw your attention to the differences that the High Court took in its approach, and the language in light of what Fee's been talking about is really quite telling. The plurality of Justices Bell, Keane, Nettle and Edelman said of this regime, it may be accepted that there remains considerable room for judicial evaluation despite the general conceptions of sections 5 and 6 as properly interpreted being deconstructed into the 6 steps. The 5th of those steps was subsection 6.1 of the measures considered to be considered appropriate. For instance, an important issue in crafting the appropriate precautionary response, so this is actually the language the High Court is using, particularly in relation to the 5th step, will be the dual axes of assessment of the gravity of the harm in prospect and the degree of probability that it will actually occur. But the process of balancing the magnitude of a risk and its likelihood when determining the burden of alleviating precautions that is reasonable or appropriate is not alien to judicial power. It's the very exercise upon which the courts engage every day in assessing whether a duty of care has been breached. So where we have the uncertainty, the plurality is saying, yes, that falls squarely within the judicial function. Now, in dissent, Justice Gagler held that, in essence, the criteria were not certain enough. And I would simply draw your attention to paragraph 161 of His Honour's judgment. Still, an irreducible requirement for any power conferred on a court to have the character of judicial power remains that its exercise must proceed upon grounds that are defined or definable, ascertained or ascertainable, and governed accordingly. That is to say, the exercise of the power must be governed or bounded by some ascertainable tests or standards. Now, without going into great amounts of detail, Justice Gagler and Justice Gordon, both in dissent, would have held that the provision was cable invalid, whereas the majority held that it was valid. But these are the questions that then attend on when, once we have ascribed moral responsibility to the state, the question is, do we... There is a moral question, there is a political question, and there is a constitutional question of the type of power that the state has to respond to that moral uncertainty. These are enormous questions. For me, Fee's paper provides an extraordinarily well-reasoned and sound foundation from which then to progress to ask these highly contingent and contested questions. For me, Fee's paper is just a terrific and insightful advance of scholarship in this area, which is going to be with us for a very long time to come. Thank you.
Thank you very much, Justice Bleeby, for those comments, and thank you so much, Fiona, for your excellent presentation. It's really very thought-provoking and interesting, and I hope everyone here has really enjoyed it. Could we just thank Fiona and Chris one more time?